Yes. See, these two clauses were the subject matter before the Supreme Court. 17.5C and 17.5D. 17.5C reads as work contract services when supplied for construction of an immovable property other than plant and machinery, except where it is an input service for further supply of work contract service. Pausing here, work contract is a combination of goods and service. So, whether to treat a work contract as a supply of goods or as a supply of service. For that, the answer lies in Schedule 2. Schedule 2 says work contract will be treated as supply of service. So, Class C deals with work contract service. Suppose if I am receiving a work contract service from somebody, that is, I have given a contract to a contractor with material to construct my factory building. Whether I will be able to take ITC of the GST charged by the contractor. That is the question. So the law says the class C is a negative provision. It's a blocked credit. This credit is not eligible. Which credit is not eligible? Work contract services when supplied for construction of an immovable property. But if that immovable property is in the nature of a plant and machinery, suppose I am constructing a factory building in which there is a big boiler which is attached to the earth and permanent. It cannot be removed from the earth. So even though it is in the nature of an immovable property, a boiler is a plant and machinery. So any GST paid by the contractor in erection, commissioning, installation of the boiler is not blocked. I am eligible to take the credit. That is one exception. If the immovable property is in the nature of plant and machinery, credit will be eligible. The next exception to the exception is where it is an input service for further supply of work contract service. I am a construction contractor. I provide work contract service to my customer. In turn, I have subcontracted a portion of the work or the entire work to another subcontractor. So that subcontractor is providing work contract service to me. In turn, I am providing work contract service to my customer. Then I am eligible to take the credit. So except these two situations, input tax credit will not be eligible in respect of work contract services. So this is the import of class C of section 17.5. Now come to class D. Goods or services or both received by a taxable person for construction of immovable property other than plant or machinery. Here they have used the word plant or machinery on its own account, including when such goods or services or both are used in the course or furtherance of business. See, section 16 says anything which is used for business or in furtherance of business, credit is eligible. 17.5 is a notwithstanding provision. So even though it is very much essential for your business, you are not given the benefit of input tax credit. That is once again reiterated in class D. You may be using that particular immovable property in your business or in furtherance of your business. Still, the credit will not be given to you. For what? Goods or services or both received by a taxable person for construction of an immovable property other than plant or machinery. Here the word used is plant or machinery, which is very crucial. Now go to the next slide. The word plant and machinery is explained. There is a definition for the phrase plant and machinery. Plant and machinery means apparatus, equipment, machinery fixed to earth by foundation or structural support that are used for making outward supply of goods or services or both, and includes such foundation and structural support, but excludes land, building or any civil structure, telecommunication tower and pipelines laid outside the factory. So, a building, however important it is for a particular factory, will not qualify as a plant and machinery. So the word plant and machinery is used only in class C dealing with work contract, whereas the word plant or machinery is used in class D. So Supreme Court interpreted this is a conscious use of the words. So this definition of plant and machinery will apply only for class C. It will not apply to class D. So whenever credit eligibility is examined with reference to class D, if the particular building can be considered as a plant, a building cannot be considered as a plant and machinery because plant and machinery definition we have, which specifically excludes a building. But A building may be considered as a plant. The word used is plant or machinery. So, if a building can be considered as a plant, for that the Supreme Court has referred to various previous decisions but has not given its finding. When a building can be considered as a plant, the Supreme Court has not answered that question. They remanded the matter back to the High Court to decide on a case-to-case basis whether a cinema theater can it be considered as a plant, a hotel can it be considered as a plant, a warehouse or a shopping mall can be considered as a plant or not. This question was left open by the Supreme Court. So actually the Supreme Court should have gone into that aspect also and laid down the law. It would have been better, but they left it open. Now, what the legislature has done, they argued the plant or machinery, it's only a drafting mistake. It cannot be given a different meaning or should be read as, and all those arguments have been taken, but Supreme Court did not agree. Now they said this litigation is going on for 4-5 years. If at all it was a mistake, you could have amended it earlier. Till now, you have not amended it. So legislature has consciously used a different word in the statute. So now they are making a retrospective amendment by replacing plant and machinery in class D also. Instead of plant or machinery, it will become plant and machinery with effect from 1/7/2017. So to determine the credit eligibility under class D also, the particular immovable property should be in the nature of plant and machinery. Your building cannot be considered as a plant and machinery as per the explanation appended to section 17.5. So this is what they have done. But the question remains, is it the end of the road? Has the Supreme Court judgment has been completely overturned by this retrospective amendment? On the one hand, this retrospective amendment itself is very, very bad in taxation law, especially in indirect taxation law. Several times our Prime Minister and Finance Ministers have spoken that we will not do any retrospective amendment. But unfortunately, in every budget, we see various retrospective amendments, both if it is in favor of a taxpayer to remove an anomaly, to clarify a doubt, it is always welcome. But a retrospective amendment of this nature to overcome a Supreme Court decision having great ramifications across the country, it does not augur well for the tax-paying community. But still, the road is not completely closed. Kindly go to the next slide. See, this is para 32 of the Safari Retreat judgment. I'll just read it. Class D of section 17.5 is different from class C in various aspects. Class D seeks to exclude from the purview of subsection 1 of section 16 and 18 goods or services or both received by a taxable person to construct an immovable property on his own account. There are two exceptions in class D to the exclusion from ITC provided in the first part of class D. The first exception is where the goods or services or both are received by a taxable person to construct an immovable property consisting of plant or machinery. That is, 17D restriction will not apply if the immovable property is in the nature of a plant or in the nature of a machinery. This they have overcome. It is not plant or machinery, it is plant and machinery. The second exception is where goods and services or both are received by a taxable person for construction of an immovable property made not on his own account. So if the construction is not for own account, the restriction will not apply. That is how class D has been worded. We will see the class D once again in the next slide also. Now, the Supreme Court goes on. It says, construction is said to be on a taxable person's own account when it is made for his personal use and not for service. Suppose I am a manufacturing unit. I construct my factory building. It is on my own account. That is on his own account. Or it is to be used by the person constructing as a setting in which the business is carried out. I am a chartered accountant. I need an office. I need an office building. I construct an office. I use it for my own office. It is on own account. The next sentence is very crucial. However, construction cannot said to be on taxable person's own account if it is intended to be sold or given on lease or license. This is an emphatic finding by the Supreme Court. So, giving a building on rent, on lease is not own account because I am not going to use that building for my own business. My business may be renting, but the building is given on rent to somebody else who is going to use it for his business. So, categorically, the Supreme Court has said leasing and licensing will not be considered as using the building for own account. So, with this, if we go back to class D, go to the next slide. Go to class D. The restriction reads as goods or services or both received by a taxable person for construction of an immovable property on his own account. So the restriction itself is only when a building is constructed for own account. What is own account? Supreme Court has said renting, leasing, licensing is not own account. That part of the judgment still remains. So, whenever a mall is constructed for lending out to other people, whenever any warehouse building is constructed and leased out to another various other parties, wherever this renting element is involved, it is not own account as held by the Supreme Court. Still, that credit will be eligible. So, the effect of this retrospective amendment will only be whoever wants to claim ITC for a building which is used on his own account. Suppose I am a manufacturer, I construct my factory building, I procure goods and services, and then whether I am eligible to take the credit or not, it is own account, credit is not eligible. But if that building qualifies as a plant and machinery, I will be able to take the credit. But the definition of plant and machinery says buildings are not included. So this retrospective amendment will have an impact only wherever credit is claimed in respect of plant and machinery or building or immovable property on own account, and giving it on rent and lease is not on own account. So majority of the cases the buildings are given on rent or lease, like shopping mall, Kalyan Mandap, all those other things. So even after this retrospective amendment, in my humble view, credit will still be eligible. This may be a very bold proposition for whatever I say. In fact, when I attempted to talk to some people, they were not willing to accept this proposition. Some people still feel that the entire judgment has been overcome. Anyway, it's a debate which is opened up. So I feel the restriction under class D has got only two and one. Whenever credit is claimed for something, an immobile property used for own account, and again when and what is own account is already held by the Supreme Court, and renting, leasing is not on own account. So this is how this retrospective amendment. So definitely the story is not over. We may have to go through another round of litigation right up to the Supreme Court in the next 10 years to get the issue resolved. And that is how law evolves over a period of time. So I think of all the amendments relating to GST, this is the one which is very important and which will have a long-term implication.